The subcommittee work session on, to make changes at family court, a subcommittee of the House Committee on Children and Family Law. We have 7 members and we do not have a quorum. What I plan on doing is submitting all the reports to all of us and let people's opinions about them be known. I was under the impression when I heard that this committee had to finish by the end of October and make our report by the 1st of November. That was a diktat. Yesterday, I talked with the Speaker's office and discovered that that message got to me in a garbled form. That, yeah, we're going to clear the decks here in the next few weeks. We can make preliminary unofficial reports by voting by email. And what I was told is that next year, if the 7 of us, or plus or minus a few, want to continue this work, we may. Or this work could be done by a committee as a whole, not a subcommittee. And I'm very encouraged by that, and I think you are too, because we will not have gotten to everything we need to. And there was a few issues that I wanted to go into the next year with, such as one judge, one case, one judge, which has been in the review reports for 30 years now. So with that, first of all, I want to hand out, you may have gotten this. If you have it, you don't need to take it. This is the assignment for the subgroups to date. And there is nothing to say that since. That's fine. Nothing to say that these subgroups can't meet on November 2nd as 2 citizens. They're not 91A forbidden, it's a subcommittee of a subcommittee. And I will tell you that because of my surgery and several other things, I didn't do my work over the summer. And I appreciate those who did. So certainly, Counselor, maybe you and I can get together in November on the one that we have.
Okay.
All right, second item here. We have, where the heck did I put it? I do have the gift of losing things while standing still. Do you have them all? Oh, good, thank you. I also have the gift of forgetting what I just did, but boy, I can tell you.
I'll give you all of them and
Okay.
Representative Markel one.
Okay.
These have all been, these have been emailed to everybody else.
Thank you.
Everybody, you got one of these in the email. And now if
Yeah, I saw that. Yeah.
Representative Raymond.
Thank you.
Both of whose hands I can see. Would make this presentation. This is Representative Gregg and Representative Raymond on improving New Hampshire Family Court pretrial and mediation practices. Good stuff. If you could walk us through it, please.
Sure. So I can kind of read what's here. So we looked at pretrial and mediation. Currently, our rules in New Hampshire allow the judges to waive many procedures, which creates inconsistent discovery, evidence, and timelines. Families report that they face delays and confusion. The Office of Mediation and Arbitration oversees the mediation and arbitration programs. It's widely used in family cases, but we've noticed that the training can vary from mediator to mediator, and the oversight is inconsistent in between different courts. There are requirements for certification to become a mediator, but there isn't a significant amount of supervision once one becomes a mediator or continuing oversight. Families involved are reporting that they're not clearly informed of their rights when they start mediation, and they don't really understand the process, or if they want to discontinue mediation, like what to do. So the problems, too much discretion can lead to unfair treatment, especially for parties who are representing themselves, which is a significant number of people here in New Hampshire. We do not have a uniform screening for domestic violence or child welfare concerns before the mediation starts. The mediation training is uneven. We have some concerns about making sure everybody has appropriate training for trauma, child development, and domestic violence. Like I said, we don't have a great system for monitoring mediator performance or investigating complaints. And sometimes families are reporting that they're feeling pressured into doing mediation instead of taking a different alternative. So doing that, we looked at some of what some other states are doing. And Oregon, Nebraska, California, and Texas all have programs that appear to be a little bit more robust than what we have here.
Would you mention those states again, please?
Sure. Oregon, Nebraska, California, and Texas. It's a nice.
Which interesting is
Diverse.
wonderfully across the political spectrum. I love this.
It is. It is a diverse group who have adopted some similar themes in how they handle mediation. So our suggestions are that we standardize pretrial orders, that we require a pretrial case management order within 30 days for family cases, that we set clear deadlines for evidence, witness lists, and hearings, especially things that are in simple language that those who are representing themselves can easily understand. That we require a mandatory domestic violence screening tool so that we can ensure that cases that families that are experiencing domestic violence don't get shuttled into mediation, because it doesn't work in cases of domestic violence. We are recommending that mediator standards for certification be increased, that there be 60 hours of training. I forget which of the 4 states had that as their standard, but that's came directly from another state. And then we're suggesting 20 hours of supervised practice, that we institute some continuing education in domestic violence, child development, trauma-informed care. And I would include child abuse and neglect in that as well, and that we include a mentorship program. I think it's Texas that has the 2-year mentorship, and it seems to work really well, and it gives new mediators someone who knows what they're doing to go to when they come up against something tricky, that is their go-to person. We're suggesting that we have an independent board for oversight, that there's a public roster, that complaints are investigated in a consistent manner, and that there's a process for removing mediators who consistently fail to manage things appropriately. Again, the plain language info sheet is important. And we would suggest that a pilot be instituted in a couple of counties first, and then to gather some data about whether or not this increased support and oversight is helpful.
So this presumably is aspirational, but as the next budget process just starts out, which isn't that long away,
Right.
This is something that can be presented to them.
Yeah, I wouldn't. My personal preference, and talking to Representative Gregg, would not be to create a bill that rolled out massive changes statewide. Although I personally think that additional training for certification and ongoing professional development is important. I think we should perhaps pilot it and have a bill for a pilot instead of making a sweeping change and then not having the funds or the staffing to follow through appropriately.
I like to say in some of the similar work I do on what you're looking at, the pilot is called the following 12 states. And you can go talk to people if you wish, but those old New Hampshire people who never drive outside of the state, we can have a few here too, but it's both. Both are really pilot information.
It is. I wish that some of the states that had this more robust mediation were closer, because I would have loved to take a field trip to Texas or California, but it just wasn't on in my budget for this summer. So
What we have done, Representative Schur and I, who are the odd couple co-leaders of what is now a bill to expand significantly mental health court, what we did is we got those people to consent to come onto a Zoom call. And we had Zoom calls with various places around the country that really cut down the travel budget. So that could be done.
that's a good idea.
Any questions that you might have?
No, let's see.
Uh-oh.
Oh, no. I read it. I think a lot of what you're saying makes some sense. Are you familiar with Family Division Court Rule 2.13?
Off the top of my head, no.
Okay, that's the one that deals with mediation.
Yep.
And what it does is that it suggests mediation. When I say suggests, it orders it, but there are some significant exceptions, such as RSA 461A7, whether or not there's been domestic violence involved. This has already been recognized in the court rules.
And it absolutely has. I think what we found, not with this special committee, but the prior special committee,
Mhm.
was that a lot of people testified that they felt that that was not sufficient, that the practice did not match the expectations.
Okay, well.
Does that
okay,
make sense? And not having been through it, I don't know for sure,
okay.
but that was a consistent theme of the testimony that we heard.
Okay, because basically the mediators have to be certified pursuant to RSA 328C. And what I run into here, I don't know, I've probably had hundreds of cases over the years. What I run into is that mediation is really, there's a question of timing. Okay, whether there's a question of timing and how well prepared you are for mediation.
Mm.
And what you end up running into is, since we're probably 80+% of the cases in family court is where one party is self-represented, the results are going to vary. And what my guess would be is that my guess would be mediation is a function of two things. Number one is whether or not the parties actually want to settle, which is sometimes too early in the case before they have enough discovery and the case has actually settled down a little bit to the point where the parties can meaningfully negotiate. The second thing is the level of preparation that parties bring to the mediation table.
Mm-hmm.
And, that's something that I haven't. And so if you order mediation too early in the process, the parties, assuming one or both are self-represented, and I'm going to assume that for the purposes of discussion and for the purposes of what the proposals are. First is that in terms of mediation, if they're talking about things like rights, and I'll get you copies of the court-ordered forms here, okay? All parties are required to sign a mediation agreement. And the mediation agreement is usually signed before mediation starts, and it contains, and I'll be happy to, I've edited some of the stuff out here, okay, just in terms of the name of the case. But they understand that mediation is confidential. They understand the mediator is impartial to help them develop their concerns. Mediators do not provide, I'll get you this, okay? Doesn't provide counseling or legal advice. You may be able to have an attorney of your own choosing. You agree to be honest and disclose all information to discussing these matters, and that everything that's said in mediation is confidential and can't be used in court, because basically they are in fact settlement negotiations, and so it's typically not admissible in court.
Do you find that is something that people struggle with?
Well, when you're dealing with pro se's, for the most part, you're dealing with people who really don't have a good handle on the law for the most part. There are exceptions to the rule, to those generalizations, of course. But you're also not, but for the most part, mediation may occur too soon in the process. Okay. The other things that I run into is that when you have the mediation participation agreement, I have a copy here. You agree you're not going to be subpoenaing the mediator in, okay? And there's a bunch of other things that they agree to, and they have to sign it before mediation starts. Or my guess would be that you're going to have to sign it very soon into the mediation before it starts, okay? The other thing is that so the courts are really addressing this already, in my opinion. The other thing is that you can have a remote mediation agreement, which means you can do it by Zoom. Okay, and a lot of mediations today do go by Zoom. I've settled cases that way. Domestic violence is a present factor, and if there are issues of domestic violence, you can, and the court's aware of them. You know, you can have a situation where mediation is not going to be indicated, or if it does, it can occur by video conferencing, like Zoom and those kinds of things. And typically, you use things like that.
I've got a couple of questions for you here.
Sure.
When you're ready. Number one, I might even suggest we add not just there is investigation of complaints, but that there be a random investigation of people who don't make complaints. How was mediation going for you? Oh, we discovered blah, 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 and it was really helpful. Well, part of the reason for that is sometimes the steam can go out of us when all we are doing is looking at what's wrong. And to be able to celebrate that there are some good things here and there are some people who have found it profitable, I think is helpful for some of us. It's also helpful to say, you know, some people don't believe this. Family court's not all wrong,
Yeah,
you know? And so I would put that in as one. And then the second thing, Counselor, I might ask of you is while, you know, I'll bet the ranch, the bill to destroy family court will not pass and will not pass by a large margin just from people across the spectrum I'm talking to. I do think that Representative Bernardi made some good points in the other thrust of his bill, which was talking about mediation. So I'm going to task you, sir, if you would, when you make your report to us on mediation, that you highlight some of the strengths that he brought up. Because my quick read, I mean, I already made my mind up once it said we're going to tear down family court, but I went back and reread it thoroughly. And I said, there's some good stuff in here that we can use. So I'm going to task you with doing that for homework. Thank you.
The other things what you're really talking about in a broader sense is alternative dispute resolution rather than going to court. And just by way of further note, there is already a court prepared form. Some mediators use it, some don't. It's called a mediator preparation form. And what it does is it asks, in a very simple way, it asks mostly self-represented individuals to describe what brought them into court, what they think about mediation so far, what can you agree on, what's important to you, and things like that. And the good part of that is that it actually is a simplified form of what many attorneys will use, which is basically a case summary and a mediation preparation memorandum. And from time to time, I use them. And it makes the mediator's job a lot easier if you go through the things that are here. And they're going to be things like what the posture of the case is, what's been done, what remains to be done, what the parties can agree on, what they can't agree on, okay, and what the areas for settlement might be, and what the disputed areas might be. And that's typically more a function of represented parties because it gives the mediators more of a handle on how they're going to settle the case. The other part of alternative dispute resolution in the family court is something that we haven't touched on, which is neutral case evaluation. And neutral case evaluation can be very effective. And it really can settle cases. It's a far more precise form of alternative dispute resolution. What it does is, it's the good part about it is it's virtually free. You use retired judges to come in, and what happens is the parties will literally marshal their evidence, bring exhibits to to NCE, and a judge will literally tell you, based on what they hear in the case, how the case is likely to resolve. So if you want to be able to spend 8 or 9 hours going to court, or 2 or 3 days going to court, and try to litigate and try to get more than what a neutral case evaluator indicates how the case is likely to settle, you're free to try.
One of the helpful things that I initiated with the New Hampshire Bar folks is what I disrespectfully call baby's first book on going to court.
Mhm.
You know, because we do have some stuff you can read or look at,
Mhm.
but so many of folks have said it wasn't nearly enough to help me do this. So this is a project I'm going to be picking up more, is what do pro se litigants really need? Because if their only education on this is reruns of night court, they're going to be in trouble, you know?
Right.
Yeah, and there's that problem with, parenthetically, as I see it, there are really two problems with it. People, I think, these are just my impressions, watch too much television, and they think that everything is like Law and Order, where the cases are resolved in 40 minutes with commercials or whatever, and it doesn't work that way. Um,
Yeah, no courtrooms are like
Yeah,
Law and Order.
it doesn't work that
But
way.
my wife and I spent all summer doing a deep dive through 26 some odd seasons of Law and Order.
Mhm.
And I started jumping up from my chair and saying objection and gave the reason. And I was agreed with by the judge on many cases. So there is some
That's good. One
educational
of the-
value there.
Yeah, one of the things that, well, as an aside, one of the things I found interesting in Law and Order, and it actually is from the 90s. Okay, it was one of my favorite shows because it actually did do a pretty good job tracking criminal procedure. So it was pretty well written. What I'm thinking here is that the family law division, may need a tweak here and may need a tweak there. The parties, I think, would be also, by the way, also parenthetically, when you receive your initial packet, either for a divorce or parenting plan, part and parcel of that packet is not only if there are minor children involved, you get the child impact seminar, but you also get, have you considered have you considered mediation? And they talk about mediation and a bunch of other things, in addition to required mandatory disclosure under Family Division Rule 125A, and a bunch of other things. And I think they're probably, and here, I just think that parties need to educate themselves as to what to expect. So if they're so they need to educate themselves if they're going to be self-represented in court. There are a couple of ways you can do that. One, there's plenty.
We're going to wrap it up because we have 2 more presentations.
I'm sorry about that. Okay, so I didn't
So
mean to roll it on like that.
I think I would just say two quick things, and I think that Representative Markell is getting to the crux of some of the issues that we're hearing from people, is that they feel lost, right? They feel overwhelmed by the amount of information that the court is giving to them, and they're finding that going through that information, it's inaccessible to them, in that they can't just sit there, read it, and absorb it, and then move forward without help.
Plus, they're at the unhappiest time of their lives.
Right. And so I think it would behoove our court system to come up with some more user-friendly options for helping people educate themselves. The Child Impact Seminar is great, but videos or things that are not written at a collegiate level could be helpful for a lot of our pro
Well,
se
let's keep
litigants.
working on this because the bar folks are amenable to helping. This.
The other thing.
All right, very quickly, please.
Okay. The other thing is that, parties do have a first appearance they attend, where the process is explained to them, and they can ask questions in it, which is part of the first appearance. I don't know exactly how much friendlier the family court, the family division can actually be. It's certainly a lot friendlier than Superior Court would be.
Thank you. I'm going to hand out two different things that Jody Nelson was going to be here to present these, but she, at the last minute, had a sick kiddo. And you could block that out. Thank you. Had a sick kiddo and had to attend to that. But this, but so she texted me this, which we downloaded out of my phone, which we downloaded into the computer here, which we printed out
Mhm.
because I had help. And one looks like the State of New Hampshire Judicial Branch request for transcripts at state expense. I think this must be in response to her subgroup. Her subgroup, cost of litigants retrieving trial transcripts which are provided by outside sources and not the courts. Representative Nelson and DeSimone had that one. So this is, I believe, what she presented on, there's the form, but then she presented the multi-page one that's stapled. Take a minute to read through that. The way state handle family matters depends on whether they have a specialized family court or whether those cases are handled within a general jurisdiction court system. And she spells out all the background questions. So take a few and read that if you would, please.
What's very interesting is the ones that have the robust mediations are not family court states.
Hmm.
Texas has family court. I retract my statement.
Wow. I think this is a fascinating document because it shows there is not just you have family court or you don't, you have a whole spectrum. And the one that I'm excited about is where there is a separate family court. Because even within the division of the circuit court, a judge is going to be doing probate one week and family stuff the next week. And that makes it a little bit more difficult, I think, to have a continuity of judge in the case. But it also says to me, you know, my wife's a doctor, and when I was little, I used to think doctors are doctors. They know about medicine. And the older I got, the more I discovered, no, they don't. They know their subspecialty, or sometimes their subspecialty's subspecialty. And I'm wondering how many of our, you know, this is not a negative against their character or a negative against their work or anything. It's just saying that some judges are going to be better at probate than they are at family. And might it not be a better idea to move, not taking family court and destroying it, but family court and enhancing it by making like Hawaii, New York, South Carolina, West Virginia, New York, Rhode Island, and Delaware. If we go on a field trip, I'm going to put in for Hawaii about February, and or Zoom session, and see how does a discrete, specialized family court where those judges only do family issues, and therefore all their continuing ed is in that, and they are chosen or their volunteering is accepted because darn it, they're good at this. They're part social worker as well as part lawyer. And that's just something that jumped out at me. Any thoughts on that, or am I just trying
So-
to get a trip to Hawaii?
I came here via New York, where I worked for 5 years, first as a forensic interviewer and then for their child protective services. And so all of the cases that I was in, well, not all, most of the cases that I was involved with um, were either a family court or a family court case and a subsequent, or it's usually after a criminal court case, because I worked a lot with sexual abuse. Um, and it's an interesting and different way of doing things. There were a lot more lawyers in New York than there are here. The parents had lawyers. There was
They have 43 law schools in New
yeah,
York.
there were attorneys for children in New York as well. So I know we have a bill that passed here for attorneys for children. That's standard practice in the court that I worked in. Um, some of the positives were that the judges really got to know the families. And we had a family drug court there as well, which was really helpful. But the downside to that was if a parent really hated the judge, there weren't a lot of other judges that they could ask for. I worked in Warren County where there was one judge and one substitute judge. So,
Yeah, in family.
and family. And that was that. So, if they needed a different judge to come in, he had to come from a different county, which created, scheduling issues and
I get the
delays.
impression that maybe one or two people who attended our hearings hated their judges.
Yep. So I didn't get the impression in the 5 years I worked there that the judge hated anyone. Frankly, but people definitely got strong feelings, and I think especially for treatment court, it can interfere with a parent's ability to move forward.
But would that not be the case where family court has judges that do other kinds of circuit court things? You can get people not liking that family court judge they get here.
Sure, I think it happens everywhere, right?
So it's not a disqualifier towards a separate family court.
Yeah.
Okay.
But it was nice as someone who was bringing cases and testifying, because you had staff that had specific expertise in that matter. So
So you have specialized staff working with specialized judges in a specialized court whose continuing education is specialized. And I mean, Representative Markell, do you see any negatives to pursuing this?
No. You know, the idea of having one judge stay with a particular case, okay, is because the judge gets to know the parties.
It's
and
the
gets
same
to
as
know the
one
subject
doctor
matter.
staying with a patient
Yeah,
throughout.
yeah, and that's pretty much the thinking behind it.
Ah.
The only exceptions to that rule is where either there's a schedule conflict or where all of a sudden an ethical conflict is I just had one of those, where an ethical conflict arises and a judge must recuse.
We find in medicine increasingly that there is not a continuity. You go to a facility that has 9 family practice physicians, and good luck who you see next time. Some places are a little better than others, but this is a growing complaint. This is why a dinosaur like the place I'm CEO of is loved. You're going to get the same physician because we make sure of it. And 4 previous special committees to review the family court highlighted the need, one case, one judge. And this will more easily be accomplished when the budget more readily provides more judges and staff. But it is something I want to continue to push for. And not, okay, we're problem solving. We have had a pretty collegial relationship working on family court here. And we're problem solvers. And let's look at the problems and let's look at how we can help them.
yeah, I mean, you and I have talked before about, I think that we have an issue with judicial staffing. We have an issue with staffing in a lot of areas, but judicial staffing. My only concern is, because family court can be a place of high emotions, that when you have one judge and no backup judges, if they get burnt out or if they want to, have some respite from the heavy work, making sure that there's a deep bench of people so that judges aren't stuck there when they're like, I really would rather go back to probate matters or whatever.
Or armed robbery or something.
Right. I'd like a break from child abuse and neglect and talk
Go
about
get that,
something
guys.
else.
Yeah, okay. Sure. You went on the road and made a field trip to a family court when you were part of special committee, yes?
Yes.
Yeah, so did I. And I think the reports I heard back were, wow, this person knows the law. This person is helping to pro se litigants. This person is compassionate. This person seems to be rooting for the family more than the family is. And I was just blown away at this combination of, yes, the law, there are rules, there are certain things, and I'm going to make decisions, but I really help. I really care for you people. I want to help.
Yeah, I've been, I don't know, I've probably sat in hundreds and hundreds of hearings before a variety of judges here in New Hampshire. And it has been consistent that I have seen judges be patient and helpful and really kind of like, especially for pro se litigants, kind of like talk them through. Are you trying to do this? Is this what you're looking to do? Kind of back and forth so that they can help the person get to where they want to go. You know, and if the answer is no, okay, well then I don't understand what you're trying to do here. Can you know,
Mhm.
share what the purposes of this? And I've seen that happen with evidentiary stuff. I know that we get complaints in here about rules of evidence changing, but I've seen the judge be like, and the purpose of this exhibit is, you know, can you tease it out a little bit for me? So I do think that there is,
Well, we have one person here who is really leaning on me heavily, sat over there where no one is sitting right now, and wanted me to push that any time a rule of evidence, he offered a rule of evidence, it must be accepted. And I said, irrespective of its probative value? He said, well, what's the alternative? I said, your soon-to-be ex-wife bringing up some extremely embarrassing things that you did in the 20s, which are not germane to this case, but will serve to make you look like a blithering moron. Is that what you want? And finally, after several back and forths, he said, well, I guess what I want is the judge accepts everything I offer, but not everything she does. I said, I thought so. So, I mean, this has to be explained. If you want rules, if you want the rules, there has to be somebody who really understands it, has good legal training that can rule whether something should be admitted or not and why. And maybe that can be in the introductory book as well, because they didn't understand it.
no, I think it goes back to lawyers go to law school for this, right? And so to ask someone with a high school education to be able to understand all of this and read a booklet or a pamphlet and then be prepared is just, it's not reasonable.
You can be better prepared
Yeah.
or less unprepared. And that is what I'm shooting for. In language one understands, um, that looks at the various issues that will come up and anticipate some of the questions and objections you will have. I don't know how many of the people who came to testify angrily had read or viewed what was presented to them, but there was some, ignorance.
Yes. But I mean, I also think, you know, I consider myself a fairly well-educated person, but I'm constantly learning new things about the law and
Oh, yeah.
family court and
Yeah.
this, you know, in this realm that I've been doing for decades. So I think that, um, I think that it can be frustrating for everyone involved.
Well, this is true. I was telling the representative earlier before you came here that have been in a study group of two people on law, one with an expert and me who's still a 1L. And I asked this person a question about certain aspect of the law. And the person said, Mr. Chairman, you know far more about it than I do because you've been studying it for a specific purpose. And then I realized, gosh, lawyers and judges are just like doctors. They don't know everything. They know a good bit about certain things. So yeah, to the point. So this is family court in certain things that come up regularly. That's what these introductory materials would be, is, not questions about dedicated trusts or anything, for example, or the 500 section of privileged communication. That's not going to be in the book. What's going to be in the book is what we do in family court. And that should help ameliorate some of the ignorance, I think. But anyway, anything further on this document? This really tells you who does what and how.
That's very comprehensive, very helpful.
Yeah. Well, there we are. And are you going to be able to be here next week?
I am not. I have a commitment in Nashua at 11 that I was not able to move, which means
Nashua,
I could be here from 9:30 until 10, which is not particularly helpful.
Well, we got a lot done in 50 minutes. I tell you what I'm going to do, because we're going to be, it looks like now, recessing this subcommittee, not terminating it. I'm going to get what we did today with some cliff notes out to the other 4 members. I will get to those who are not here next week, what is presented next week. And we can certainly call each other one at a time on the phone, not to violate a 91A, because although we are not a committee or a subcommittee, we are members of the committee. So we can do our little work and continue what we haven't gotten done because of my fault over the summer, and work on that informally. And should we be stood up again, starting next year? I mean, that's a different use of the term stood up. I mean, we'll go to work from there. So thank you all, and we're done. Go see who the orange badge is on.